A New York federal court, 2023. A pair of practicing lawyers filed a brief containing 6 cases that did not exist, were sanctioned $5,000 for the filing, and watched the story go around the world within 48 hours. The lead case in the fabrication, Varghese against China Southern Airlines, became the most famous citation that never was. Every working lawyer who has even considered using AI for legal research remembers that case by name, and most of them remember it as the reason they have not yet adopted the technology in any serious way. 3 years later, the pattern has not stopped. It has spread. Court filings containing fabricated authority show up in state courts, federal courts, immigration tribunals, and arbitration proceedings across multiple jurisdictions, and the sanctions keep coming. The total dollar value of sanctions imposed on lawyers for AI-assisted hallucinated citations is now in the high 6 figures and rising. Problem is not theoretical. It is the single most career-defining risk in legal AI used today. And the panel has spent considerable time thinking about how to address it at the prompt level, rather than waiting for the verification step to catch every error. This episode walks through 5 cues that materially reduce the rate at which Claude invents authority before any verification work happens at all. The cues do not eliminate the need for verification. Nothing eliminates the need for verification. But the cues shift the failure rate before the verification step begins, which means fewer fabricated citations in the draft, fewer items in the verification pass, and lower total risk on every brief that gets filed. Most discussion of legal AI hallucination focuses on verification, which is the right downstream defense, and which the panel has covered in Foundations number 6. The verification protocol catches fabricated citations after the draft exists. The protocol works, and it is non-negotiable. But verification runs against a finished draft. Every fabricated citation in the draft costs verification time, and every verification failure is a near miss. A senior practitioner reviewing a junior associate's brief with 5 fabricated citations spends meaningful time finding each one, killing each one, and rebuilding the argument around the real authority that exists in its place. The work is honest. The work is also avoidable upstream of the verification step. What the panel wants to spend this episode on is the upstream layer, the cues that shift the rate at which the model fabricates citations in the first place. The 5 cues that follow are prompt-level interventions, used at the moment the lawyer is requesting research from the model, and each one is doing a specific job that the model responds to in a measurable way. Used together, they reduce fabrication rates substantially. Used in isolation, each one helps. Used alongside the connector layer from the Claude for Legal release, they compound further still. This is the work the panel has been doing for the last 18 months, refined through repeated use on real matters, and it is the most concentrated risk reduction technique in the Foundations sequence. Before walking through each cue in detail, the panel wants to name them all at once, because the structure of the 5 together matters as much as any individual cue. The first cue is source restriction. You tell the model where it can draw authority from, and you tell it explicitly that fabrication outside those sources is forbidden. The second cue is jurisdiction anchoring. You specify the jurisdiction and the temporal scope of the inquiry, which dramatically reduces the rate at which the model reaches for plausible-sounding authority from adjacent jurisdictions or from cases that are no longer good law. The third cue is the citation discipline cue. You ask the model to mark uncertainty in its citations explicitly and to flag any citation it is not fully confident in for your attention, rather than presenting it with false confidence. The fourth cue is the negative instruction cue. You tell the model explicitly what fabrication looks like and that you do not want it, which sounds simple and is, but which also works in a way that surprised the panel the first time they tested it carefully. The fifth cue is the verification handoff cue. You ask the model to identify which citations in its output most need verification, and to flag the ones it considers highest risk for your verification pass. The model knows, in a meaningful sense, which of its own outputs are most likely to be wrong, and asking it to surface those explicitly is a small piece of work that pays back quickly. 5 cues, used in sequence within a single research request. The panel walks through each one in detail next. The first cue is the most important of the 5, and it is also the one most lawyers underuse, because the natural research prompt does not include it, and the model does not prompt you to add it. Source restriction means telling the model explicitly which authority sources you will accept in the response, and telling it equally explicitly that authority drawn from outside those sources is forbidden. The prompt structure that works reliably is something close to the following. Cite only from cases reported in Westlaw or in the Court Listener Federal Database, with full reporter citations. If a relevant proposition exists in your knowledge, but the case cannot be confirmed in one of these sources, say so explicitly and do not provide a citation. What this cue does, in measurable terms, is shift the model from a default of produce plausible-looking authority to a default of produce authority I can confirm in a database the lawyer specified. The shift is large. Combined with the connector layer in the Claude for Legal release, where the model is actually reaching into Westlaw or Court Listener as it composes the response, the fabrication rate drops to near zero. Without the connector layer, the cue still works because it changes how the model weights its own confidence in any given citation. Source restriction is the cue you use on every research request, every time, no exceptions. It is the single biggest defense against fabrication, and it costs you roughly 12 words of prompt overhead per request. The second cue addresses the failure mode where the model produces a citation that exists but is wrong for the jurisdiction or the temporal window of the question. A real case from a different state. A real case that has been superseded by statute. A real case that is now bad law because of subsequent appellate history. These failures look correct on the page and are sometimes harder to catch than pure fabrications because the citation is verifiable, but the citation does not actually support the proposition for which it is being offered. Jurisdiction anchoring means telling the model explicitly which jurisdiction's law applies, what temporal window matters, and what procedural posture you are working within. The prompt structure looks something like the following. This research question is governed by Delaware law post-2019 in a contract dispute at summary judgment posture. Cases from other state jurisdictions or from before the temporal window are relevant only if they have been adopted in Delaware, in which case cite both the out-of-state authority and the Delaware case adopting it. What this cue does is force the model to apply a jurisdictional filter at the citation selection stage, rather than producing the most rhetorically useful case and leaving the jurisdictional check to the lawyer. Combined with Q1, the citations that come back are substantially more likely to be both real and jurisdictionally appropriate. This is the cue that catches the failure mode the panel sees most often in mid-level associate work. Real cases, wrong jurisdictions. The cue addresses it at the source. The third cue addresses a more subtle problem. The model, left to its own defaults, produces every citation with the same level of confidence in its presentation, regardless of whether the citation is from a leading case the model has clear context on, or from a borderline case the model is reaching for to support a proposition it is not fully sure of. The result is that the lawyer reviewing the draft cannot tell, from the surface of the citation, which of the cited cases are most likely to be the weak points in the brief. Every citation looks equally authoritative. The lawyer has to dig into each one individually to assess strength, and the time cost compounds across the brief. The citation discipline queue asks the model to flag its own uncertainty. The prompt structure is something like the following. For each citation, indicate your confidence level. High confidence for citations from leading cases where the proposition is directly on point. Medium confidence for citations where the proposition is supported but requires interpretation. Low confidence for citations that are reaching, or that you would not include if you were instructed to be conservative about citation strength. What this queue does is surface the model's internal confidence ranking, which the model has and which the practitioner can use. The low confidence citations get verified first and most rigorously. The high confidence citations get the lighter verification pass. The total verification time drops and the failure mode coverage improves because the lawyer's attention is concentrated where it matters most. The fourth queue is the one the panel found most counterintuitive when first testing it, because it sounds too simple to work. You tell the model explicitly what fabrication looks like, and you tell it explicitly that you do not want any. The prompt structure is something like the following. Do not invent case names, citations, or authority. Do not combine real case names with fabricated citations. Do not extrapolate from real cases to produce citations that sound plausible but cannot be confirmed in the sources specified above. If you cannot find authority for a proposition, say so explicitly and offer to research the proposition further or to suggest where the lawyer might look. Do not fill the gap with plausible-sounding fabrication. What this queue does is name the failure mode the model is otherwise likely to fall into, which causes the model to treat fabrication as a distinct behavior to avoid, rather than as the path of least resistance default when authority is hard to find. The queue works because the model can recognize the pattern when it is named, and the recognition reduces the rate at which the pattern occurs. The panel was skeptical of this queue when it was first proposed, because the intuition is that adding a do not hallucinate instruction sounds like it should not work. The testing showed otherwise. The queue does work, and the effect compounds with the other four queues rather than replacing them. The fifth queue is the one that connects this episode to the verification work from Foundations number 6. You ask the model to identify in its own output which citations are most likely to require careful verification, and to flag the ones it considers highest risk. The prompt structure is something like the following. At the end of your response, list the citations in your output by risk level for verification purposes. Identify the 2 or 3 that, in your judgment, are most likely to be the citations the lawyer should verify first and most rigorously, and explain briefly why each one is flagged. What this queue does is surface the model's own risk assessment as a working artifact for the lawyer to use. The model knows, in a meaningful sense, which of its own citations are most likely to be problematic. It knows when it has reached for a case that is borderline, or synthesized a proposition from multiple sources, or provided a citation it has lower confidence in than the others. Asking it to surface that ranking lets the lawyer direct the verification pass where the risk is highest. The queue does not replace the verification protocol. It focuses the verification protocol. The 15-minute verification workflow from Foundations number 6 runs on every citation that matters. The verification handoff queue makes sure the highest risk citations get the most careful attention within that workflow. The 5 queues work best when they are combined into a single research prompt, rather than added piecemeal across multiple requests. The prompt that runs all 5 together in the panel's working practice looks something like the following. For this research question, cite only from cases reported in Westlaw or in the Court Listener Federal Database with full reporter citations. If a proposition exists in your knowledge, but the case cannot be confirmed in one of these sources, say so explicitly and do not provide a citation. This question is governed by the law of the relevant jurisdiction, in the relevant temporal window, at the relevant procedural posture. Apply that filter strictly. For each citation in your output, indicate confidence level, high, medium, or low. Do not invent case names, citations, or authority. Do not combine real case names with fabricated citations. If you cannot find authority for a proposition, say so explicitly. At the end of your response, list the citations by verification risk and identify the 2 or 3 most likely to require careful verification with brief reasoning. That is one prompt, about 90 words of overhead on top of the underlying research question. The output that comes back is materially different from the output that comes back to the same research question without the 5 cues in place. The panel uses this prompt structure as a template for every research request, and the template is worth saving in the lawyer's working drafts as a copy-paste asset. 3 things the 5 cues do not do, and the panel wants to be explicit about each one because overstating what the cues accomplish is itself a risk to the practitioner who trusts them too completely. The cues do not eliminate fabrication. They reduce the rate. The reduction is meaningful, and on most research questions, the rate of fabrication in the response drops substantially when the cues are applied correctly. The rate does not drop to 0. The verification protocol from Foundations number 6 still runs on every citation that matters, with the cues helping but not replacing the underlying check. The cues do not work on every kind of question. Research questions where the underlying authority is well developed in the model's training and well represented in the specified sources benefit most. Research questions on specialized regulatory areas, on emerging case law, or on jurisdictions where the model has thinner coverage see smaller improvements. The cues help in those contexts too, but the residual risk is higher and the verification work correspondingly more important. The cues do not eliminate the lawyer's judgment. The model can surface citations, flag confidence, and rank verification risk. The lawyer decides which case actually supports the argument, which citation goes into the brief, and which authority gets cited in support of which proposition. That work is still the lawyer's, and it always will be. That was the protocol. 5 cues that materially reduce fabrication rates at the prompt level, used as a single research template designed to compound with the verification protocol from Foundations number 6, rather than to replace it. The Foundations series continues. The next episode covers how to prep a witness in 90 minutes, which extends the by Tuesday morning family into the deposition prep context, and walks through a 4-pass protocol the panel uses when the deposition starts at 5 and the matter file needs to be read from scratch. The episode after that covers how to brief a partner on a matter you have not seen in the 15 minutes before the call. For practitioners using the Claude for Legal release, the connector layer walked through in Unpacked number 4 makes the first cue substantially stronger because the model is reading from Westlaw and Court Listener directly rather than relying on the cue to constrain its own output. The other 4 cues apply equally inside and outside the Claude for Legal environment, and the panel recommends using all 5 regardless of which surface you are running Claude through. Save the 5-cue template, paste it at the top of every research request. Verify rigorously through the protocol from Foundations number 6. The lane is moving fast, and the practitioners who have these defenses in place now are the ones who will avoid the sanctions list when the next wave of fabrication cases hits the courts. That's the episode. See you in the next one.